Our next, also on an advertising theme, is Jeanette Versace to talk about Breaking Ad, about the advertising ombud. While she's just getting ready, she disclosed yesterday to me that she still has a milk tooth. So I'm not too sure how that fits in. Over to you, Jeanette.
Yeah, Darren asked for something interesting about everyone, so I just told him that something was weird about me. Just to put it out there, no one's looking inside my mouth today. So, because usually when people find this out, they want to see the tooth, which is weird. Now that Lisa's covered advertising law in the rest of Africa, it might be convenient to look at some developments locally. Some of you might have heard that the Advertising Standards Authority of South Africa has applied to be accredited as an industry ombudsman scheme for the advertising and marketing industry in South Africa in terms of the Consumer Protection Act. Now, this may or may not have an impact on every single organization or business that is represented here today, and basically in the whole country. So we'll have a look at that. As most of us probably know or have experienced, historically the ASA has been quite an effective tribunal or body to deal with advertising complaints in South Africa, quite effective and sometimes less costly than going to the courts. However, recently there have been some challenges at the ASA, and we're going to look at two today. Firstly, reports in the past year or two have indicated that the ASA has been facing some financial difficulties. Now, the reason for this is because it's a voluntary association. The members' contribution towards the funding of the ASA is also generally voluntary. So the ASA doesn't always have a fixed amount coming in, and they need to make do with what they receive. A second issue is there've quite recently been two judgments handed down by the High Court in Johannesburg dealing with the jurisdiction of the ASA. Now, historically, when a complaint was filed against an advertiser in South Africa, that advertiser would generally entertain the complaint, take part in the complaint, and comply with the sanctions or the order made by the ASA. However, two separate entities in the pharmaceutical industry took the ASA's jurisdiction to the High Court, or the issue of the ASA's jurisdiction, and basically the courts have held that only members of the ASA are required to comply with the ASA's current advertising code of practice, and the ASA only has jurisdiction to consider complaints against members of the ASA unless a non-member says, well, okay, I'll abide by the ruling and I'll comply with your judgment. The reason for this is basically that the courts have held that the relationship between the ASA and the member is a contractual agreement, and an agreement between two parties cannot bind an independent third party. So therefore, a non-member cannot be bound by the ASA code, and the ASA cannot order a non-member to, for example, withdraw its advertising. Now, luckily, there's a solution to these two issues on the horizon, and that's basically the accreditation of the ASA as an ombudsman scheme in terms of the CPA. Basically, in terms of Section 82 of the Consumer Protection Act, the Minister of Trade and Industry, in consultation with the National Consumer Commission, can accredit a specific body in the industry as an ombudsman scheme for alternative dispute resolution. And the Minister may also accredit a specific code for that industry. Now, against this background, in the Government Gazette of the 26th of July this year, a proposed industry code for the marketing and advertising industry, which will now fall under the Consumer Protection Act, was published for public comment. Now, the deadline to submit comments to this code was a week ago, and I'm aware of about 24 entities and organizations that submitted comments. So some of the issues or some of the provisions in the proposed code are quite controversial and need clarification. What the National Consumer Commission, which receives the submissions, has done is they've now referred all of these submissions to the ASA. The ASA has set up a code review committee that now has to look at all of the submissions and, where appropriate, make revisions to this proposed code and obviously deal with issues as they arise. Fortunately, we are part of this committee, so hopefully we'll be able to assist with putting a code in place that will assist everyone. Now, if we look at the code as it was published, this proposed code, we're going to look at the effect and the scope. One of the important definitions is participants and subscribers in the advertising and marketing industry. Basically, the code says that this definition is so wide that it includes advertising agencies, media buyers, and media owners, but also every single business or entity that advertises its goods or services in South Africa. So basically everyone represented here, because everyone markets to some extent, might fall within this definition. Now, all of these participants and subscribers will be required to, 1, register with the ASA, 2, comply with the industry code once it's come into force, and 3, contribute towards the funding of the ASA. Now, going back to the issues that the ASA currently has, the jurisdictional issue will be solved because everyone will have to comply with the code, and secondly, because the funding pool will be widened, hopefully the funding problems of the ASA will be something of the past. That being said, the funding issue is quite controversial because as the code is currently published, it's quite vague, the provisions, and a lot of people have asked, well, how will this work? All that the code says is that there will be a levy collection agency established for basically getting all of the funds. What the ASA has now done is they've put together a work group to look at what other ombudsman schemes are doing and to create some other funding model which hopefully will be reasonable to everyone in the industry. So we'll see what happens then. Now, the industry code as it was published overlaps to a certain extent with the current ASA code. But because it has to fall within the parameters of the Consumer Protection Act, there are also some differences. When reading the industry code, what immediately comes to mind is the fact that, or comes to light, is that there's a lot of emphasis on consumer rights. And this makes sense if you consider the fact that it falls within the Consumer Protection Act. The persons or entities that will be able to institute complaints against participants and subscribers remain the same. So either a consumer or a competitor or otherwise a non-profit organization with an interest in a specific matter. If we look at the complaints procedure, it's basically also the same as the current ASA code. So a written complaint will be lodged with the ASA and considered by the ASA directorate, and there'll be 2 appeal levels basically. From the published code, it appears that at least on an appeal level, by a competitor, you'll have to lodge a filing fee, which is the current case. It's not clear whether if you file the initial complaint, if a competitor fee will be applicable as well. The sanctions that the ASA will be able to order are a bit more limited. Basically, there are 3. 1, withdrawing the offending advert. 2, publishing a summarized version of the order or the ruling in certain types of media. And 3, submitting the amended ad for pre-clearance. And then looking at the overlap or some clauses that have been included or excluded, the provisions relating to truthful substantiation and no misleading advertising have been included. However, a lot of the provisions on which competitor complaints are generally lodged, so disparagement, exploitation of advertising goodwill, imitation, those do not appear in the industry code, and this is actually a concern. But I was at a meeting at the ASA's offices last week, and they said, well, after considering various concerns and issues raised in this regard, they believe that in the revised industry code, these provisions should be placed back, and we agree with that. So looking at where we are currently at this stage, the ASA is continuing as per usual, and the ASA code as it is applicable, bearing in mind the jurisdictional limitations based on the High Court rulings. I must say that the ASA has obtained leave to appeal one of the matters, so we'll see what happens there. Once the proposed industry code has been revised, the ASA will submit that to the National Consumer Commission for consideration. If they're happy with that, they'll approach the Minister of Trade and Industry and ask him to accredit the ASA and to approve the industry code. And once that happens, basically the ASA will fall within the Consumer Protection Act as an ombud. The industry code will apply, and the ASA code as it currently stands will fall away. So that's where we are. And then I found a quote online which I think is quite indicative of the government's intention to protect the public interest by advertising. And it basically says, stop trying to sell with marketing, but instead use marketing to help customers buy. There we go.
Thanks, Jeanette. I think we're going to take a break just after questions, just to freshen up. We're running slightly over time, but we'll make it up in the next session. But before we do that, are there any questions for Jeanette and our Bud the Ombud? Right, I sense that coffee is a welcome alternative. I don't think it's because your talk wasn't interesting. It's about the future. Do you know when this thing's going to, or in time periods? We're looking a year, half a year? What
Well, the Code Review Committee wants to submit a revised code to the National Consumer Commission by mid-December. So I don't think much is going to happen by until the first quarter of next year.
Okay, something to look forward to.